final case to come before the court today is Kenneth Owens versus Ford Motor Company. Each party will have 15 minutes to present its arguments. To the appellate, you wish to reserve up to 5 minutes for rebuttal. Please let me know when you take the podium. The arguments are being visually and audibly recorded to be posted online, so please keep your voice up and remain behind the podium. We've read your briefs and we are ready to begin.
Good morning. May it please the court, my name is Corey Kuzma. I represent the appellant, Kenneth Owens, in this matter. I'd just like to first quickly thank the court for granting there's 2 motions to continue this oral argument, one from each side, both due to medical reasons. We appreciate you accommodating so we can both be here. We're here today on our appeal of the trial court's decision to exclude our
Rebuttal.
3 minutes, please.
Okay, go ahead.
To exclude our expert, Dr. Joseph Totaro, chiropractor, from effectively testifying at the trial, giving his causal expert opinion on the matters of some soft tissue injuries that were alleged additional allowances in a workers' compensation claim. I'd just like to explain, we'll get into the abuse of the discretion that the trial court had in this matter. By first pointing out page 20 of the trial transcripts, the trial judge incorrectly, inaccurately states that I provided the court with 2 cases that day. One, Shackelford versus Cortec, and Smith versus Fry. In actuality, the trial court provided Smith versus Fry the morning of the trial, giving both me and Mr. Krantz notice that my expert, Dr. Totaro, was going to be excluded and not allowed to testify via videotape deposition that day. Essentially to give our video discovery team notice that the video was not going to be played. We proceed with the trial, we have the jury, and then a break between 12:30 and 2, that's when I came up with the Shackelford case after doing some quick analysis and case law. I'll get into the facts of Shackelford and the other cases that I noted in my brief. I think it's important to note this because it's the trial court, this speaks to the abuse of discretion, it's the trial court that acted to exclude my expert right before the trial. They read the transcripts the day before. They saw Mr. Krantz's objections, not the first time, but the second and third time where I asked Dr. Totaro to testify, give his expert opinion, strictly just to a medical certainty only. No motions to exclude or motions in limine were filed to exclude the doctor. The court acted on their own, providing Smith versus Fry, stating that the 9th District has case law supporting that you can exclude a chiropractor from testifying as an expert, and then turned around and used Shackelford, which I provided with the court after that break, but using it in an incomplete and inconsistent way to further support their decision to exclude my expert. That is the abuse of discretion, the standard that we know we have to meet here today in our appeal and in our brief, and I believe this situation more than supports the criteria for that. Again, it's the court moving, it's the court providing the case law, then placing the burden on me to effectively explain that day why they should not kick my doctor, supplying the case law from my point of view, and then the incomplete analysis they used, applying Shackelford. I feel the case law in this situation is overwhelmingly in our favor. The cases I cited in my brief, I think they lay a really good groundwork of the analysis that should be done. First noting Shackelford is pretty much the main case established in the 7th District, the 12th District. I'm essentially providing that a probative value analysis should be done in the case. In that one specifically, that the chiropractor was asked to testify both to medical and chiropractic certainty, but the takeaway for the case would be the term medical, which could, but not always, could be used in traditional ways. The fact is, it does not in itself, the medical term, does not in and of itself outweigh the probative value of the testimony itself. If there's analysis that needs to be done, I think the further cases Green versus BWC Administrator, that's the 7th district. They take Shackelford, kind of apply it, expound on it. They still allowed a chiropractor, again, in a workers' compensation matter, to testify solely only to medical certainty. And the reason for that is because they laid the groundwork from the chiropractor testifying, explaining his or her background, what their degree was in, their experience, their training, their involvement in the case, solely as a chiropractor, and only testified to medical certainty. The case essentially said the probative value of the testimony was still outweighing any prejudicial instance that could be found by using the term medical. Finally, Batista versus Ameritech is an 8th district court, which I think fully kind of summarized everything. I feel it's very on point in this case. Both situations had chiropractors testifying in workers' compensation claims. Both explained their chiropractic background and training in the matter. Both explained their involvement in the case. And both were asked to state their opinion to a medical certainty. The one sole difference in Batista versus this situation, which I'll gladly point out, is that the plaintiff's attorney in Batista asked at least once to testify to a chiropractic certainty. Everything else after that was to a medical. The court still allowed the testimony as there was analysis that was done, applying Shackelford again, that is important to look at the background, the totality of the testimony as a whole, and figure out if the probative value outweighs any potential harm the term medical could use. That's the exact same situation here. Dr. Totaro explained his medical background as a chiropractor, his training, his experiences, his current practice, his education, where he graduated from, page 6 of his deposition. Stated simply that he was not a doctor when asked on cross, it's page 34. Chiropractic terms throughout. He explained what kind of treatment he gave to Mr. Owens, what kind of records he reviewed after establishing that he was a chiropractor. Generally given an opinion on soft tissue injuries in this case, which chiropractors are allowed to do in workers' compensation claims based on the revised code and rules of evidence. I feel there was no chance the jury would have been misled to believe Dr. Totaro was a medical doctor or testifying as one. He didn't need to. There was no need for a medical doctor to testify. There was no explanation, there was no testimony on his part to try to get the jury to believe that, should they have heard his testimony.
Was this even going to be a jury trial?
It was. The only reason we waived the jury is when the court notified us in the morning they were going to exclude Dr. Totaro, or at least his causal opinion, effectively wiping away his testimony, in order to still go forward and not have to sit through jury selection and essentially go through all the process. We both agreed to waive the jury to get right to everything and appeal it. Batista, I think, like I said, it's on point. Importantly, the court in this matter in Batista, they speak directly to the trial court's decision, an explanation in the trial transcripts, that the trial court essentially said Shackelford only applies to cases where a chiropractor was asked to testify to both medical and chiropractic certainty. Batista, the court in that specifically rejects that. They said the court must look at the totality of the testimony as a whole, see what the expert is testifying to based on their training and education, and if they are able to testify to those matters based on totality, everything, their background. In this case, Dr. Totaro was more than qualified to do so.
Counsel,
Yes.
Because we only have the order appealed, which is the final order saying that directed verdict is granted, and then we have some discussion, I'm hoping, an argument on the record regarding why the doctor's videotape deposition doesn't come into trial. Is it clear from the trial record that the reason why it was excluded was because of these questions being of medical certainty versus chiropractic certainty and not some other reason?
I think so, yes. Looking at the transcripts from the trial court, again, as I said, the court notified us off the record in the morning to kind of give us notice. That's when they supplied with the case law. But the transcripts, I think it lays out, the judge said, he asked me to call my witness, I called Dr. Taro, he said, based on previous discussions, we're excluding that, and then he does the analysis of Shackelford. Incomplete without looking at other cases. I wish I could have provided them that day, but like I said, the court handed me Smith versus Fry the day of, a half an hour before trial, saying your expert's going to be kicked. Shackelford was the main case that comes up. That's what we applied. They did an incomplete analysis of it, but he does go through specifically states, because I did not ask my doctor to a degree of medical and chiropractic certainty. That's why my doctor was getting kicked.
And then was there an opportunity to argue the point? I understand let me rephrase that. I understand this is new information, but is there an opportunity to argue that to the trial court, that the trial court's exclusion on that basis is incorrect? On the record?
On the record, no, besides the court does note, that the trial judge does note that I provided incorrectly, I have not provided Fry versus Smith, but Shackelford, he goes through the analysis, and I just objected, reserved my right for this appeal after that. They essentially said, again, it's not on the record at that point, but that it was going to be excluded even after giving them that Shackelford before we came back from the break. But again, Batista, I think going through, they specifically reject that argument that Shackelford only applies when chiropractors are asked both medical and chiropractic certainty. I believe a read through more than supports case law-wise for our position. Specifically, it looks like it's paragraph 31 from the case printout I had with Batista. Again, the case law, 7th, 8th, 12th districts, I think all find in our favor. With the Shackelford case, Green, Batista, I think not reversing and remanding back down would create inconsistent law between the districts. And Shackelford, I think, is still the main case to look at because it provides that probative value analysis. When done correctly, provides a fair explanation, looks at everything. It just doesn't focus on any procedural or small inconsistencies or issues a trial, a testifying expert might have. Again, I just want to note the court acted on its own in this case. There's no motions in limine, no motions to exclude. If I had a doctor that I thought was testifying outside the scope of their expertise or giving an opinion that they're not able to give, those would have been filed. This was the morning of, this is the trial court acting. And then, again, giving that incomplete analysis of Shackelford on the spot and then denying it one way or another. I think that's the abuse of discretion in this case. Thank you.
Good morning, Your Honors. My name is Tim Krantz. I represent Ford Motor Company on behalf of the appellee. As you know, the trial court has great discretion regarding admission of evidence, and the appellate court can only reverse if the trial court has abused its discretion. And as we know, an abuse of discretion is more than an error of law. It must be unreasonable, arbitrary, or unconscionable. And of course, the appellate court cannot substitute its judgment for that of the trial court. The main issue, as you know by now in this case, is that of Dr. Tartaro's testimony, and the court's excluding it insofar as he was a chiropractor, and at no time was he ever asked his opinion to reasonable degree of chiropractic certainty, only medical certainty. The seminal case, as discussed by counsel, is Shackelford. Shackelford held that a chiropractor is qualified to give an opinion to a reasonable degree of medical and chiropractic certainty. I think what's interesting in Shackelford is they indicated if it was or medical or chiropractic certainty, that may be a problem, and that they may not allow that in because that's an improper way to ask that. The trial court did exclude the chiropractor's opinion. However, the Court of Appeals found there was an abuse of discretion and reversed that. But what's important in Shackelford is that the case found that it disclaims any construction allowing a restricted practitioner to give expert testimony beyond his limits of expertise. Obviously, Shackelford is different than what we have here, as there was absolutely no reference by counsel or any questions posed regarding chiropractic certainty. I mean, you might want to ask yourself, If a chiropractor is allowed to testify to reasonable medical certainty or probability, what about a psychologist? They're in the medical field. Are you going to ask a psychologist to testify to reasonable medical certainty? I mean, I think you have to make a distinction here that a chiropractor is not a medical doctor, and had counsel even asked, are your opinions to reasonable degree of chiropractic certainty, that would have fallen under the auspices of Shackelford. Batista, as indicated, is an 8th District case. In that case, the employer argued the chiropractor's testimony was improper because he testified to medical certainty. Of course, that is distinguishable because the counsel in that case did ask a preliminary question to the chiropractor to phrase his opinions in the context of chiropractic certainty, and the court found that the subsequent reference to medical certainty was inadvertent. Obviously, we don't have that case here. As the court indicated on 3 different occasions, counsel asked the doctor if his opinion was to medical certainty, that is Dr. Totero. The Green case, 1991, 7th District, trial court granted the motion for directed verdict by the Bureau of Workers' Compensation. The appellate court reversed, saying merely recited Shackelford and did not get into any great analysis or reasoning as far as the holding in Shackelford, but we also, the judge relied upon Smith versus Fry, which is a 9th District case. The trial court excluded the chiropractor's testimony. However, in all fairness, there was no specific indication by the court why they excluded the chiropractor's testimony. It would have been helpful if they indicated why it was excluded. The dissent does reference the Shackelford case again, which indicated that they allowed the chiropractor to testify to reasonable medical and chiropractic certainty. The judge relied upon the Shackelford case and to a lesser degree the Smith versus Wright case, and looking at the testimony of Dr. Totero and concluded that it was insufficient. Let's talk about the motion for directed verdict. That tests the legal sufficiency of the evidence. To overcome that, the record must show the sufficient evidence that a reasonable jury could render a verdict in plaintiff's favor. There must be more than a scintilla of evidence. If you look at the evidence in this case, clearly there's insufficient evidence presented by the plaintiff to establish that he sustained the conditions of cervical, thoracic, lumbar, and right shoulder strain sprain as a result of an incident, a very minor incident at Ford on June 13, 2014. There must be a direct and proximate causal relationship between the accident and the injuries. Briefly, if I can talk about the evidence by the plaintiff, it was clearly speculative and conjecture. If you look at the lack of evidence, Mr. Owens on cross-examination admitted he didn't have any pain in his neck, right shoulder or back at the time of the incident. He testified that he told his supervisor he was okay after the incident and did not want to go to the medical clinic. He testified he told the nurse at the Ford clinic that he just had a headache. There was no contemporaneous medical evidence to show that Mr. Owens injured any of the areas he claimed, his neck, his mid-back, his low back, and right shoulder. If you look at the 4 dispensary records which were admitted into evidence, there were no complaints to any of those body parts. As a matter of fact, on one of the records on June 13th, Mr. Owens denied that he had any neck pain. Significantly, another record admitted into evidence, a June 15th, 2014 visit by Mr. Owens at the Hoosier Medical Center. He complained of a headache, and there was a diagnosis of post-concussion syndrome and I believe concussion. Interestingly, this is 2 days later, 48 hours later at least, and there's no complaints of neck, back, right shoulder, and there's absolutely no diagnosis by the ER at Hoosier of any of those injuries. And if you recall Dr. Totero's testimony, he indicated on cross that if he did have those injuries, they clearly would have shown up within 24 to 48 hours. Again, there was no reference by Mr. Owens, or no complaints in the Hoosier records. There are other records September 5th, 2014 at Abuja, no complaints of those areas. The bottom line is, there were no mention of any neck, mid-back, low back, or right shoulder problems until he saw Dr. Totero over 4.5 months later. I mean, clearly that's the only evidence they have, and there's such a huge gap here between the complaints of these areas and the original incident that clearly it goes to the sufficiency of the evidence. Additionally, if you look at Dr. Totero's testimony, it has to be to probability, not possibility. Dr. Totero was asked by his counsel, or I should say counsel for the plaintiff, many times if Mr. Owens could have sustained the alleged soft tissue injuries.
Counsel, how do we reach that issue if we have the exclusion of Dr. Totero's testimony?
Well, I think in the directed verdict, the court is allowed to consider all the evidence that was submitted by the plaintiff, which was the entire testimony of Dr. Totero and the medical records. That was part of the evidence. So although the court clearly focused on the issue as far as the chiropractic versus medical certainty, clearly if you look at, the court has to weigh all the evidence, and if you look at the testimony, could have clearly does not equate to medical probability. You look at the Shoemaker versus Oliver Buchanan and Sons, it requires testimony by probability. By asking Dr. Totero could have just equates to possibility. That goes to the sufficiency of the testimony of Dr. Totero, even if you should find that he should not have been excluded based upon the chiropractic versus medical issue.
Well, as I asked opposing counsel, is it clear from the trial court record the reason for the exclusion of the testimony?
Well, I think the court focused primarily on the chiropractic versus medical certainty issue, but of course, you know, the court has to consider all the evidence before it, which would include the documentary evidence and the testimony of Dr. Totero, to render a decision that reasonable minds could come but to one conclusion. Again, he did focus primarily on that issue, the medical certainty, but he does have to consider all the evidence before it and whether that's sufficient to override a motion for directed verdict. In light of the exclusion of Dr. Totero's opinions, which I think were appropriate in this case, again, the trial judge has the discretion to do so. There was case law supporting his decision to do so. There's no reference to chiropractic anywhere in the questions asked by counsel, so I clearly think the trial judge was within his discretion. I don't think it could be found that he was unreasonable, arbitrary, or unconscionable based upon that. Based upon that and his exclusion of Dr. Totero's testimony, there can only be one decision that he made, and that was to grant defendant's motion for directed verdict. And I know if you look at, I know you've read the transcript, if you look at that, I did indicate all the other reasons for why a directed verdict should be granted, the insufficiency of the testimony of Dr. Totero. So based upon that, I think the trial court did not abuse its discretion by excluding the testimony and granting a directed verdict, and I would ask you to affirm the trial court's decision. Thank you.
Thank you.
Thank you. I'll be brief. Green versus Administrator BWC. Very, very similar fact situation. That was the directed verdict in that case was granted. It was appealed. It was overturned based on Shackelford. That was a case from 1991. I think we even have more ammunition on our side in case of court at this point because we have Batista, which is 2008. So even years after Green was decided and overturned for abuse of discretion, we have the same situation here, only with another case in between supporting us, I think, 100%. In terms of the directed verdict issue, it was granted because our doctor's causal relationship opinion was thrown out. We could not win at that And Mr. Krantz, to his credit, he starts arguing about factual facts in this case, and those are all jury questions. Questions that didn't get to the jury because we had no expert at that point after it being kicked. So those are the issues that I wish we could have gotten before jury and have them decide whether or not Mr. Owens' testimony was credible, how effective Dr. Totaro's testimony really was. Those are questions for the jury to answer. We couldn't get there, direct verdict was granted, and here we are on appeal. Just again on Smith versus Fry, that is a personal injury case from the best I can read it. It's not workers' compensation. It doesn't touch upon the question of medical certainty versus chiropractic certainty. It's literally just a 9th district case that they kicked the chiropractor. It looks like a motion limiting was filed in that instance about a year before the trial. They knew the chiropractor was going to get kicked for whatever reason. The best I could come up with is, in that case, it says the chiropractor was potentially going to testify to permanency of injuries and was not allowed to do that. I don't know if it just wasn't in his or her expertise, or if it was too premature to actually determine that, or maybe they were diagnosing something outside of what a chiropractor can. In this case, this is not the situation. It's all soft tissue injuries. It's all sprains and strains that he was more than qualified to testify to. In my preparing for doctors' depositions, and Dr. Taro specifically, I wanted to make sure he laid out his foundation of what he practices, what treatment he gives, what conditions he specifically treats and diagnoses and gives. Those are what I focused on. Unfortunately, he was only asked to medical certainty 3 different times. It was objected to twice, and that's what led to his exclusion. There was no case law supporting the exclusion of Dr. Taro's testimony, literally until I gave Shackelford and it was applied incorrectly.
Okay. Thank you.
Thank you.
Thank you both for your presentations. Court will take the matter under advisement, issue